I remember a very lovely air stewardess looking after me. I was all over the place, just getting through lots of tissues and crying. And then I thought, look, I've got to get a grip here and do something useful for Diana.
Diana brother shocks Camilla's family as lawyers, confirm the estate is no longer theirs. Okay, stay with this for a moment, because that title is not simply about an old family property changing hands. The claim at the center of this story is far more uncomfortable. Lawyers were reportedly asked to examine an estate that Camilla's relatives had long treated as part of their family's secure future, and the review allegedly reached a conclusion that nobody in that circle wanted to hear. The documents did not support the ownership position they believed they had. The room changed the moment that finding was placed on the table. According to the account behind this story, Diana's brother had pushed for the legal status of the estate to be examined after questions emerged around historic ownership records, family agreements, and later arrangements. What had once looked settled suddenly appeared uncertain. And that distinction matters, because this was not merely a disagreement over who should live in a house. It was a question over whether the family had been treating an estate as theirs when the underlying paperwork allegedly said something very different. Now, watch this carefully. The most explosive part was not that lawyers had discovered an old document. It was what the document appeared to do to years of confidence. People connected to Camilla's family had reportedly believed the property was protected by generations of family arrangements. They had apparently treated that assumption as something solid. Then the legal review began pulling at the records, one piece at a time, until the certainty started to crack. And that is where this story becomes difficult to ignore. Because if a family has spent years believing that an estate belongs to them, what happens when lawyers suddenly say the evidence does not support that belief? Who gave them that confidence? Which agreements allowed it to continue? And most importantly, what provision could have been sitting inside the paperwork all along, waiting for someone to finally read it closely? Hi viewers, if you discovered that something your family believed belonged to them for years was suddenly being challenged by lawyers, would you want the truth exposed, even if it caused a major family fight? If you would, leave a simple yes in the comments, because that one word says you would rather face an uncomfortable truth than protect a comfortable story.
It was my turn to get up there, and I'd been a broadcaster, so I knew how to speak, I thought, but it was very different to do that on behalf of my sister in front of 1.5 billion people, or whatever it was.
The reported dispute did not begin with a public announcement or a dramatic confrontation in front of cameras. It allegedly began with a legal question. Diana's brother reportedly wanted the estate's position examined properly, not through family assumptions, not through promises, not through what people had always been told, through the records themselves. That distinction became crucial. For years, the estate had apparently carried an identity within the family that was stronger than the paperwork being examined. It was associated with Camilla's relatives. It had become part of their expectations. Family arrangements had allegedly reinforced the idea that its future was secure. When people repeatedly hear that something is theirs, when they see it treated as theirs, and when nobody openly challenges that belief, the assumption can become more powerful than the original document that created it. But lawyers do not work from assumptions. They look for dates, names, transfers, clauses, amendments, signatures, restrictions, beneficial interests, and the exact wording that can turn an apparently simple inheritance question into something much more complicated. That was reportedly what happened here. The review began comparing historic ownership records with later family agreements. The deeper the examination went, the more discrepancies allegedly appeared between the old documents and the arrangements that followed. Some provisions seemed difficult to reconcile. Some later understandings appeared to depend on an interpretation that the legal records did not clearly confirm. Then came the question that reportedly changed the mood around the entire dispute. If Camilla's family really had a secure claim, Where was the document that proved it? It sounds like a simple question. It was not. A family can rely on tradition for decades. It can rely on private assurances. It can rely on what one generation tells the next. But when lawyers are asked to establish ownership, tradition is not enough. The paper trail has to survive scrutiny. And according to the account behind this story, that paper trail began producing uncomfortable answers. The reported findings allegedly suggested that the family's long-standing position was not as secure as they had believed. The lawyers were not simply questioning a minor technicality. They were examining whether the legal foundation underneath the family's claim actually existed in the form everyone assumed. That is why the reaction reportedly became so tense.
Very early on, I tripped over a word. And I remember thinking, that was a real wake-up call to me. I thought, no, you've got to get this right. And then I think I probably just read off rather than looking around and doing what you're meant to do. I just thought, right, I've got to get to this.
For Camilla's relatives, this was not just a legal inconvenience. It threatened expectations built over years. It raised questions about plans already made around the property. It forced people to reconsider statements and assurances that had once seemed unquestionable. And it created the possibility that arrangements made in good faith could suddenly look very different when placed beside the original records. There was another problem. Senior advisors reportedly wanted the dispute handled privately before it became a wider public embarrassment. That request alone suggested that the issue had moved beyond a routine disagreement. If the matter could have been dismissed easily, there would have been little reason to urge both sides toward a quiet settlement. Instead, the pressure increased. One side had the family history and years of expectation behind it. The other side had lawyers asking a much colder question: what does the documentation actually say? And somewhere inside that documentation was reportedly the provision capable of changing the entire argument. This is where the story stops being about an estate and starts becoming a question of control. Because once lawyers begin challenging the foundation of an inheritance claim, every later arrangement becomes relevant. Every agreement can be examined. Every promise can be questioned. Every decision made on the assumption of ownership can suddenly carry a different meaning. The most unsettling possibility was not that someone had simply misunderstood a document. It was that the misunderstanding may have been allowed to survive for years. There is also a human side to a dispute like this that legal language can easily hide. An estate is not only bricks, land, gardens, or a name in an old register. It can represent belonging. It can represent security. It can become part of how a family imagines the future. That is why a challenge to ownership can feel like a challenge to identity itself. For the relatives involved, the lawyers were not merely reviewing history. They were potentially rewriting expectations that had been passed down, accepted, and acted upon. And once those expectations were placed under legal scrutiny, nobody could simply pretend that the question had never been asked. The longer the review continued, the harder that question became to avoid. The documents were still not finished telling their story. That is the mystery now hanging over the dispute. How did the assumption become so powerful? Why was the legal position apparently not confronted earlier? And what exactly did the lawyers find when they went back through the records far enough to uncover the provision that reportedly changed everything? The answer, according to the story, was buried deeper than anyone expected. And if this account is right, the next part was where the dispute stopped being a question about what the family believed and became a question about what the documents could actually prove. So stay with this story, because if you think losing an estate is the worst part, the next discovery makes the first shock look small. And if you believe the truth should not be buried behind family power or private promises, subscribe now and stay for what the lawyers reportedly uncovered next. The estate had never needed a courtroom to look like it belonged to Camilla's family. That was the problem. For years, The property had been surrounded by the quiet signals that make ownership feel unquestionable. Family arrangements pointed toward one future. Private expectations followed. People connected to Camilla's side reportedly behaved as though the estate was already settled, even though the legal position was far more complicated than appearances suggested.
And then by the end, I was completely wrung out emotionally, and I couldn't breathe. And I can remember the last 30 seconds or so, I was punching it out of the bottom of my stomach through using the muscles in the base of my stomach, because my lungs, I just sort of had enough.
Take a look at what that means. Ownership can be recorded in one place, managed through another arrangement, and influenced by agreements made years later. To an outsider, those distinctions can disappear. Inside a powerful family, they can become accepted as normal. A property can remain associated with one branch of a family long enough for everyone to stop asking the most basic question: who actually has the legal right to decide its future? That question mattered because the estate's history reportedly contained several layers of arrangements. The original records were not being viewed in isolation. Lawyers were examining how the property had been handled over time, including later agreements that may have shaped what different relatives believed they were entitled to expect. This is where the story takes a different turn from a simple inheritance dispute. The issue was not only who had occupied the property or who had been associated with it. The issue was whether later family arrangements had created expectations that went further than the underlying ownership documents allowed. That distinction could explain why the situation remained quiet for so long. If everyone involved believed the arrangements were settled, there was little reason to challenge them. A family does not normally reopen decades of paperwork simply because a technical question might exist somewhere inside an old file. People rely on established practice. They trust previous generations. They assume lawyers dealt with the difficult parts long before they arrived. But assumptions become dangerous when ownership changes, family structures change, or someone finally asks for the original records. According to the account behind this dispute, that is what the legal review forced into the open. The estate had reportedly been treated as a secure part of Camilla's family future. That belief could have been reinforced by private assurances and later arrangements. Those assurances may have carried real emotional weight, especially if relatives were told that the property would remain connected to their side of the family. Yet a promise and a legal entitlement are not necessarily the same thing. That difference became central to the lawyer's work. Instead of asking what relatives had been told, the review had to ask what rights had actually been created. Instead of relying on family memory, the lawyers had to trace the chain of documents. Instead of accepting later arrangements at face value, they had to determine whether those arrangements were consistent with the original legal position. That process can be uncomfortable because old documents rarely exist in isolation. A later agreement can depend on an earlier provision. An amendment can change the effect of a previous clause. A family understanding can survive long after the reason behind it has been forgotten. And that appears to be where this estate became vulnerable to challenge. The reported discrepancies were not necessarily obvious to someone looking at a single document. They emerged when different records were compared. Historic ownership information had to be measured against family agreements. Later arrangements had to be examined against what came before them. The lawyers were effectively reconstructing the estate's legal history to find out where the family's understanding and the documentary record had separated. That is a much more serious exercise than simply finding an old deed. It asks when the assumption began. It asks who relied upon it. It asks whether later decisions were made because people genuinely believed they had authority. And it asks whether anyone had ever tested that belief against the original terms. For Camilla's relatives, the answers mattered because their expectations may have been built on that chain of understanding. If the earliest documents created a limitation that later arrangements could not overcome, then every subsequent assumption had to be reconsidered. That would also explain the reported urgency surrounding the dispute. The longer an assumption survives, the more difficult it becomes to challenge without causing disruption. People make plans around it. Money may be spent. Conversations about the future may become more definite. Family members may begin thinking about rooms, responsibilities, maintenance, access, or eventual inheritance. None of those actions automatically creates ownership, but they can make the eventual discovery far more painful. That is why the legal review reportedly unsettled more than a property claim. It threatened the expectations attached to the property. There was also a question of family authority. If previous relatives had arranged matters in a way that made Camilla's family believe the estate was secure, who had actually authorized those arrangements? Were they based on a legally binding right, or were they based on permission that could later be withdrawn? Had someone misunderstood the limits of their own authority? Or had the family simply inherited an interpretation that nobody had thought necessary to challenge? Those questions could not be answered by reputation. They required records. And the records reportedly led the lawyers toward a provision that had not carried much practical importance in the family's day-to-day dealings, but could become decisive once the ownership dispute was examined closely. That provision is the point where the story becomes much more serious. Because if it merely confirmed what Camilla's relatives already believed, the dispute would have had a straightforward ending. The lawyers could have pointed to the document, confirmed the claim, and closed the file. Instead, according to the story, the review moved in the opposite direction. The more closely the lawyers examined the history, the less secure the family's position appeared. That does not automatically mean anyone deliberately misled anyone else. The available account does not establish that. It leaves open several possibilities. The family may have relied on old advice. Later arrangements may have been interpreted too broadly. Documents may have been overlooked. Or different people may simply have understood the same family agreements in different ways. But whatever the explanation, the result was the same. A property that had felt settled suddenly required a legal explanation. And once lawyers begin asking for the document that supposedly proves ownership, every confident statement made before that moment becomes less important. The question was no longer whether Camilla's family had always regarded the estate as theirs. The question was whether the law had ever agreed. The timing also mattered. By the time the review was underway, the dispute was no longer confined to a quiet question between relatives. Lawyers were now comparing documents with the authority to challenge assumptions that had survived for years. That changed the balance completely. A family belief could be defended emotionally, but a legal conclusion had to be defended with evidence. And once the evidence became the focus, the people who had relied most heavily on the old understanding faced an uncomfortable choice: produce the document that supported their position, or explain why everyone had believed something the records could not confirm. That choice was becoming unavoidable, and nobody knew what the next document would reveal. Because the next document could change everything they thought they knew again. If this story matters to anyone who believes powerful families should be held to the same standard as everyone else, do not scroll past it. Like this video, share it, and subscribe, because staying silent while the records are questioned only leaves the old assumptions standing. And the next part is where the lawyers reportedly found the provision that could make the entire family claim collapse. The document was only a few pages long, but according to the account behind this dispute, it carried a weight far greater than its size. It was the kind of paperwork most people would never read unless something had already gone wrong. Dates sat beside names. Clauses referred back to earlier agreements. Terms that sounded harmless in isolation became much more serious when read alongside the estate's older records. This was no longer about what relatives remembered. The lawyers were now tracing the exact legal route by which control of the property had supposedly passed from one arrangement to another. Then they reached the provision that mattered. The wording reportedly placed a limit on the rights that could be claimed through later family arrangements. That detail was critical because Camilla's family's position appeared to depend heavily on arrangements made after the estate's original legal framework had been established. If those later arrangements could not override the earlier restriction, then the family's confidence in its future claim had a serious weakness. Take a moment here, because this is where the entire dispute turns. A family can inherit an understanding. It cannot automatically inherit a legal right, simply because generations have repeated the same story. The lawyers were reportedly separating those two things line by line. The first question was whether the later family agreements had actually transferred ownership. The second was whether they had created only permission, access, or an expectation. The third was whether any such arrangement could survive the original restriction attached to the estate. Those questions led the legal team deeper into the records. One document reportedly referred to the estate in a way that did not match the language used in later family arrangements. Another contained wording that appeared to preserve an older limitation. A subsequent agreement seemed to assume that the family had authority to make decisions about the property, yet the lawyers were reportedly unable to find a clear provision granting that authority in the form the family had understood it. That was the problem. The documents were not necessarily saying that nobody connected to Camilla's family had ever had access to the estate. They were raising a different issue. Access was not the same as ownership. Use was not necessarily the same as beneficial entitlement. A family arrangement could govern how a property was managed without giving someone the power to decide who would ultimately own it. That distinction reportedly became the lawyer's central concern. It also created a difficult question for anyone who had relied on the later arrangements. If those agreements did not establish ownership, what exactly had the family been relying on? The answer appeared to involve a provision that had remained largely invisible in ordinary family dealings. According to the story, the clause had not been treated as important because nobody expected it to be tested. It sat quietly inside the estate's legal structure, overshadowed by later agreements and the practical reality of how the property had been handled. But once Diana's brother's legal team began reviewing the history, that old provision reportedly became impossible to ignore. The lawyers then had to examine another issue, whether later documents had been properly authorized. This mattered because even a carefully written agreement cannot necessarily change a protected legal arrangement unless the people with the required authority approve the change. If the original structure imposed conditions on future ownership, those conditions could not simply disappear because relatives reached a private understanding years later. That possibility reportedly changed the tone of the review. The lawyers were no longer looking only for evidence that supported Camilla's family's claim. They were testing whether the claim could survive every relevant restriction in the chain of documents. That is a much harder test. A single supportive agreement might strengthen a family's position, but if an older provision directly limits what that agreement can accomplish, the later document becomes far less powerful. And according to the account behind this story, that was precisely the problem. The legal team reportedly found that the historic framework carried a restriction that later arrangements had not clearly removed. The wording mattered, the timing mattered, and the authority behind each later agreement mattered. The result was uncomfortable. The family could point to years of arrangements. The lawyers could point to the original legal structure. Those were not necessarily the same thing. Then another question surfaced. Who had been treating the later arrangements as if they were conclusive? That question carried a different kind of risk because it shifted attention away from the property itself and toward the decisions made around it. If people had been told the estate would remain available to Camilla's family, those assurances may have influenced private plans. If money had been spent because of those expectations, the dispute could involve more than hurt feelings. It could raise questions about responsibility. The account behind the story suggests that this is where senior advisors became increasingly concerned about the possibility of a private settlement. A settlement could contain the dispute. It could prevent a complicated family disagreement from becoming a public legal battle, but a private settlement could not erase the document the lawyers had already found. That was the difficult part. Whatever the family chose to do next, the underlying provision would remain part of the estate's legal history. And there was still one issue the lawyers had not resolved. What did the provision actually mean for the family's long-standing claim? The wording reportedly appeared clear enough to undermine the assumption of permanent ownership, but legal interpretation can depend on surrounding documents and the exact structure of an agreement. That meant the lawyers had to test the provision against every relevant amendment and later arrangement before giving a final conclusion. This is where the review became painstaking. They traced the documents backward, then forward. They checked dates against amendments. They compared names and references. They looked for evidence that the restriction had ever been formally removed. According to the story, they could not find the clean transfer that Camilla's family would have needed to make the ownership position as secure as they believed. That finding was significant. But the lawyers still had one final task. They had to determine whether the later arrangements could be defended as evidence of a legitimate family interest, even if they did not create outright ownership. That distinction could affect what happened next. Because if the family had no ownership, but did have some recognized interest, permission, or contractual expectation, the dispute might still have room for negotiation. If there was no enforceable right at all, the situation was much more severe. The lawyers reportedly reached a conclusion after examining the documents together. The estate could not be treated as belonging to Camilla's family simply because later arrangements had made it appear that way. The historic restriction remained decisive, and that meant the question of ownership had finally moved from family belief into legal territory. That confrontation carried a harder question than ownership alone. Someone had to explain why the family built expectations around the estate for so long, and whether those expectations had been supported by enforceable rights. The answer could embarrass both sides if assurances had encouraged decisions that documents could no longer defend in public. The next step was no longer another document search, it was confrontation. Someone would have to tell Camilla's family what the lawyers had concluded. And once that happened, every private assurance surrounding the estate could be challenged in the same room. If you think the family should have been told the truth the moment this provision was discovered, make your voice count with a like and a share, because the next chapter is where the legal finding reportedly leaves the paperwork and turns into a direct family confrontation. The confrontation did not begin with shouting. It began with a question that left very little room for comfort. According to the account behind this dispute, representatives of Camilla's family were presented with the lawyer's conclusion and asked to respond to the legal position surrounding the estate. The expectation on their side was reportedly that the long-standing family arrangements would carry enough weight to settle the matter. Instead, the legal team focused on the documents. That changed the conversation immediately. The family's position could be explained through years of practice. The lawyer's position had to be explained through the records. Those two forms of authority were now sitting across from each other. One side could point to what had been accepted for years. The other could point to what the paperwork allegedly allowed. The difference was becoming impossible to ignore. The first response was reportedly straightforward. The family's representatives questioned whether the historic provision had been interpreted too narrowly. If later agreements had been made and followed for years, they argued, surely those arrangements had legal significance. They were not asking anyone to accept a random family story. They were relying on a chain of decisions that had apparently been respected over time. But the lawyers were reportedly prepared for that argument. They went back to the distinction that had caused the dispute in the first place. A later arrangement could have practical importance without automatically creating ownership. An assurance could explain why people acted with confidence without proving that they possessed the power to transfer the estate. A family understanding could be genuine and still fail to override an earlier restriction. That was the point the lawyers refused to let disappear. The disagreement became more personal when the discussion turned to the promises that had apparently shaped expectations around the property. If relatives had been told that the estate was secure for their side of the family, then they wanted to know who had made those assurances and on what authority. That question put pressure on everyone involved. A promise carries one kind of weight inside a family. A signed legal provision carries another. The two had collided. Diana's brother, according to the story, had not entered the dispute simply to challenge a family tradition. The legal review had been requested because the estate's status needed to be established. Once the lawyers reached their reported conclusion, backing away would have meant leaving the original question unanswered. So the challenge remained. Where was the document that transferred the estate in the way Camilla's family believed? The response reportedly pointed back toward later arrangements. The lawyers reportedly pointed backward again, to the original framework. That exchange became the heart of the confrontation. Each side was effectively asking the other to accept a different definition of certainty. Camilla's family had certainty built through history, conduct, and expectation. The legal team had certainty built through the wording of the records. Neither side could simply erase the other. Then the senior advisors entered the picture. According to the background supplied for this story, advisors urged both sides to resolve the matter privately before it reached the public. That pressure revealed how serious the situation had become. A disagreement over a private estate could be contained. A dispute involving prominent royal connections, contested inheritance expectations, and lawyers challenging the family's understanding could become something much larger. A private settlement therefore became attractive. But settlement had its own problem. It could decide what happened next. It could not change what the historic documents had already said. That meant any agreement would have to confront the legal finding rather than pretend it did not exist. The family representatives reportedly wanted clarity on what the lawyers were actually claiming. Was the estate completely outside their legal rights, or was there some remaining interest that could be preserved through negotiation? That was the opening they were looking for. The lawyers reportedly gave them little comfort. The issue was not simply whether relatives had been allowed to use the property, it was whether they had a legally protected claim to its future ownership. Those were different questions, and the distinction was becoming decisive. Then came another uncomfortable point. If the family had been relying on later arrangements that did not establish ownership, what happened to decisions made because of those arrangements? That question widened the dispute. It potentially reached into years of planning, private expectations, and financial decisions. The story does not establish that every such decision was unlawful or improper. It does establish the central uncertainty. If the foundation of the family's claim was weaker than believed, then decisions made on that assumption could no longer be viewed in exactly the same way. That was enough to make the room tense. Nobody needed to raise their voice. The implications were already doing the damage. The family's representatives reportedly pressed for a compromise. The legal team, however, remained focused on the estate's underlying status. Any compromise would have to acknowledge that the documents did not support the ownership position as confidently as the family had assumed. And then the conversation reached the question nobody wanted to answer. If Camilla's family did not own the estate, who did? The answer was more complicated than simply naming another relative. Ownership, control, beneficial interest, and future succession could all depend on the structure created by the historic documents. The lawyers had reportedly been careful not to confuse those separate concepts. That caution mattered because giving a quick answer could create another misunderstanding. Instead, The legal team reportedly explained that the first conclusion was negative. The documents did not establish the family's claim in the form they had believed. The positive answer about the estate's ultimate destination required another step. That was the moment when the dispute changed again. The family had entered the confrontation, wanting to defend an inheritance expectation. They now had to listen to lawyers explain why that expectation could not simply be treated as ownership. The emotional impact was unavoidable. Years of confidence had been reduced to a question of legal authority. The estate still stood where it had always stood. Nothing physical had changed. The rooms remained, the land remained, the history remained. What had changed was the meaning attached to it. For Camilla's family, the property could no longer be discussed as though its future were already decided. For Diana's brother, the legal review had achieved its immediate purpose. The old assumption had been tested. But there was still a final problem. A finding that the family did not own the estate was only half of the story. Someone else had to have the stronger legal position. And according to the account behind this dispute, that answer was about to create an even more uncomfortable question for everyone involved. Because the next issue was not simply who lost the estate, it was who would ultimately control what happened to it. That was the point where the lawyers reportedly moved beyond the disputed claim and toward the estate's actual future. And that revelation was more damaging than the family had expected. And that final question carried its own danger. Whoever emerged with the stronger claim would inherit more than property. That person would inherit responsibility for deciding what happened next. The lawyers had opened the door, but they had not yet shown everyone what waited behind it. Until that answer was given, nobody in the room could safely assume the dispute was finished. The answer would also determine who held the keys. If you think a family should not be allowed to hide behind old promises when the documents say otherwise, make your position clear with a like, share, and subscription, because the final chapter is where the estate's future is revealed and the consequences become impossible to ignore. The answer was not waiting in another family promise. It was waiting in the legal consequence of the documents already examined. According to the account behind this dispute, once the lawyers concluded that Camilla's family could not establish the ownership position they had long assumed, attention shifted to the estate's future. That changed the question completely. The argument was no longer about defending an old expectation. It was about determining who had the authority to decide what happened next. That distinction mattered because an estate can have a complicated legal structure. One person may have a right to use it. Another may have a financial interest. A trustee may hold powers over its management. A later beneficiary may have rights that only become effective after certain conditions are met. The family's reported assumption had treated these different interests as though they were one thing. The lawyers were reportedly no longer willing to do that. They separated the rights from the expectations and examined what remained after the disputed claim was removed. The result was not an instant transfer to another family member. It was a process of identifying the next valid legal position under the existing arrangements. For Camilla's relatives, that meant the estate they had regarded as secure was now outside their control unless a new agreement could be reached. That was the real consequence of the finding. The property itself had not disappeared. Its history had not been erased. But the family's presumed future had been taken off the table. And there was another complication. Any attempt to settle the matter privately would still have to respect the underlying legal structure. A settlement could resolve disagreements between the parties, but it could not simply rewrite historic documents without the authority required to do so. That made the advisors push for a quiet solution much harder. The reported dispute, therefore, reached a point where everyone had to distinguish between what they wanted and what the documents permitted. Diana's brother had reportedly triggered the examination by demanding that the estate's status be properly reviewed. His role in the story was now clearer. He had not merely challenged Camilla's family publicly, He had forced the question back to the paperwork. That decision had consequences. If the review had found clear evidence supporting the family's position, the challenge would have collapsed. Instead, the lawyers reportedly reached the opposite conclusion. The estate could no longer be treated as though Camilla's relatives automatically owned it. That finding became the defining moment of the dispute. The family's representatives were left with fewer options. They could continue challenging the interpretation, they could seek a negotiated arrangement, or they could accept that the estate's future would have to be determined through the legal framework rather than family expectation. The account does not establish which private conversations followed or what every participant believed. It does, however, present a clear turning point. The old assumption could no longer operate as the final answer. That is why the dispute was reportedly so difficult to contain. The issue had exposed a gap between public perception inside the family and the legal position described by the lawyers. Once that gap became visible, every future decision involving the estate had to be reconsidered. There was also a symbolic consequence. The family had reportedly spent years treating the property as part of its future. Now that future was uncertain. Plans connected to the estate could no longer be treated as guaranteed. Any expectation of eventual ownership had to be tested against the same records that had caused the original shock. For the lawyers, the conclusion was procedural. For the people affected, it was personal. An estate that had represented security could suddenly represent uncertainty. A property associated with one branch of a family could become the subject of a completely different succession decision. And a private understanding that once seemed powerful could lose its force when compared with the original legal terms. That is the uncomfortable lesson at the center of this story. Ownership is not established simply because people behave as though it exists. The next question was who would take responsibility for the estate under the remaining legal structure. According to the account behind this story, that answer did not produce the outcome Camilla's family had expected. Instead, the estate was set to move toward another eligible beneficiary under the arrangements governing it. The significance was not simply that one family lost an anticipated inheritance. It was that the estate's future could now be determined by a legal mechanism that had existed independently of the family's later assumptions. That is what made the earlier provision so important. It had not needed to dominate family conversations for years. It only needed to remain legally valid. Once the dispute forced that provision into the open, it became more powerful than years of informal expectation. The story therefore ends where the legal review began, with the documents. They had challenged the assumption. They had forced the family to reconsider its position, and they had redirected the future of the estate. But there is one point that should not be overlooked. The account behind this dispute is built around allegations and reported legal findings. Without independently verified court records or complete ownership documents, no responsible narrator should claim that every private detail is established fact. What can be followed within the story is the central conflict. A long-standing family assumption was reportedly tested against historic records. Lawyers allegedly found that the ownership claim did not hold in the form expected, and the resulting dispute forced both sides to reconsider what the estate actually represented. That distinction matters because the strongest part of the story is not simply the shock. It is the question underneath it. How can a family become so confident about an inheritance that nobody thinks to challenge the assumption until lawyers finally return to the original documents? That question reaches beyond this estate. It touches every inheritance dispute where family memory, private promises, and legal rights become tangled together. And for Camilla's family, according to the account presented here, the answer arrived too late to preserve the certainty they once had. The estate was still standing, the family history was still there, but the claim was no longer being treated as settled. That is why the title matters. The shock was not merely that lawyers questioned an estate. The shock was that the lawyers reportedly confirmed something far more damaging. The property could not simply be treated as belonging to Camilla's family because everyone had believed it did. The old assumption had reached its limit. Now the consequences belonged to whoever had the lawful authority to determine the estate's next chapter. And that leaves one final question for the audience. Was this a long overdue correction of a family misunderstanding, or should years of accepted arrangements have carried more weight? If the documents really do tell a different story from the one powerful people have repeated for years, ignoring that difference only protects the old assumption. So if you believe the truth should be examined, no matter whose reputation is involved, like this video, share it with someone who follows these royal disputes, subscribe to this channel, and turn on notifications, because refusing to look away is the only way these questions keep getting asked. And stay close, because the next story coming to this channel goes even deeper, with another royal family dispute where the paperwork reportedly raises questions nobody expected to see. And when private promises collide with legal records, the person who thought they were protected can discover that confidence was never protection at all. That is precisely why the final document mattered, and why the people waiting for the answer reportedly understood that the dispute was not finished yet.